we'll move on into individual caretakers versus Christine M. Schwartz. Counsel, do you wish to reserve any time?
Yes, Your Honor. 4 minutes, please.
4 minutes. You got it, sir, and you may proceed.
May it please the Court. Good morning, Your Honors. My name is Gary Thompson. I'm from Washington, D.C., and I'm here today on behalf of the appellants, the individual caretakers. First, thank you very much for granting my motion to allow speech, and please be before the Court. Your Honors, the issue here today is about procedural due process. Were the individual caretakers entitled to intervene below to argue the deprivation of their First Amendment liberty interest before the trial court ordered that their names, addresses, telephone numbers, and other personal information be disclosed to the public? Should the judge have at least allowed the individual caretakers most affected by that disclosure to intervene and simply be heard? The individual caretakers of Alabama, or Gibson, the case involving the Florida Supreme Court, or Graham, or any of the others, if you change that fact pattern to one where the NAACP has a limited relationship with the state to carry on some public purpose, would that result have been different? And I don't think it would have.
And add in at the caveat that they agree to be subject to the Public Records Act.
Well, I don't think that there is such a thing as an agreement by the network to be subject to the Public Records Act for all purposes. It was a very carefully negotiated memorandum of understanding. They were given express promises by the county that these personal records would never be revealed. That was expressly laid out in the memorandum of understanding, and that's why it very carefully recites.
Isn't a fair interpretation of that promise, though, that they would never be given voluntarily? Obviously, if you've got a law that says they have to disclose them, then that would trump that promise.
Well, what the memorandum says, Your Honors, is that they promise to disclose the location of cat colonies by district. They fulfilled that promise. They produced maps of the colonies by district. It was all given, and that is consistent with both the express terms of the memorandum and the parole evidence. But that's not really the issue here. We're not really here to reopen the public records issue at all. What we're here to argue is that the individual caretakers wanted to enter this discussion. They did not necessarily want to focus on the public records issue because, let's assume for a second they're public records. And I'm willing to concede that for purposes of this argument. Well, it's not in every single case the fact that a record is public doesn't automatically trump private or First Amendment interest. It's a balancing that has to be done. So it's public. On the other hand, if you come forward and assert a general right to privacy, we know that that's not enough to tip the balance back. There are cases in Florida that say there's no general right of confidentiality or privacy and information. But once you enter First Amendment liberty interest into the equation, that is a critical fact that should have caused the trial judge to at least have heard from the caretakers. All they wanted was a voice. And if they had a chance to argue below, they would have proven that they had been subject and are subject to personal threats. These are, in most cases, elderly ladies taking care of feral cats. Their cats have been killed. Their cats have been tortured and maimed, left on their doorsteps. They've been personally threatened. The fact that their personal information, their names and phone numbers are out there, creates an incredible fear for them. And they're finding their cats killed or maimed all the time. Now that this registry, or at least part of it, is out there, it is having a severe chilling effect on their willingness to come together through an organization to advocate for political and social change. When that type of liberty interest is at stake, we don't just automatically say public trumps that.
Why don't you form another organization that doesn't have an agreement with the county?
Well, I suppose, if the NRA were ordered to produce their membership list, they could just form another organization. But that can't be the answer for how we protect.
Yeah, but as a practical matter, doesn't that make you fit directly under NAACP versus Alabama, and you don't have the difficulties associated with this organization?
The problem is the information's, at least part of it is already out there, and it's important to notice that the order itself is not limited to the membership list. It states
Have these
that
names been turned over at this point? Was it stayed by the appeal?
it was not stayed. There was a production of particular registry that showed the names of all the members of the Space Coast Ski Line Network, all their home addresses. The order itself says every record held by the network of any kind or any of its predecessors, no matter what it is wide open to public disclosure.
And has that already been disclosed?
That particular record has, Your Honor, but everything else is subject to disclosure. There's all kinds of forms in their files. This order is like a sword of Damocles over their heads. It's saying to them, your whole lives, all the personal information you've given into this network to collectively advance the interests of the network are subject to disclosure. And that's horribly unfair, and it creates a real serious threat in a very serious sense for them about something that they care most about in the world. And they just wanted a chance to be heard. They wanted to introduce their evidence, have their testimony heard. The judge below may have said, all right, I've heard from you, interveners, thank you very much. I'm going to go now and balance the public versus First Amendment equation in accordance with the law. But what we're talking about right now is not the substance of the argument, because we're getting into the substance. What is the meaning of their First Amendment liberty interest? Are these public records? I mean, that's an important discussion, but it's a discussion that can only be had in light of evidence. And so the real error here right now is the procedural due process error.
When did they move to intervene? Wasn't it after the ruling had already been made by the judge?
It was within 48 hours of the issuance of the order. And, of course, they were not a party in the proceedings at all.
I understand that.
These individual caretakers were not in the proceeding below. When the order was issued, word of mouth spread, and they happened to hear about it, and, a chill went up their spine. So within 36 hours, they were able to find counsel and get some papers filed. The information had not yet been disclosed, and once the judge got that motion, if the trial judge had said, okay, stop, let's hear this evidence, no harm would have been done. There was no timeliness, there was no compelling reason to disclose the information. He should have stopped and heard their evidence and then made his ruling in accordance with the law.
But does the record reflect why Dr. STORTS wanted the information?
I'm not sure that it does, Your Honor. We're confused about her purpose. We don't know if she has a public purpose or a private agenda or some organization that she's connected with has a private agenda.
She's just a vet down here.
I can't really comment on that. But if I may, I want to point out 3 cases that are very prominent in Dr. STORTS' briefs. In case after case that has been cited, and they go both ways on the actual outcome, the one thing they have in common everywhere is the interveners were heard, or the persons most affected by the order were heard. Sometimes they're actual parties in the case. So as parties, they're automatically get to be heard. But
when you say the interveners were heard,
yes.
Were they heard after they were accepted as interveners?
Yes, in most cases.
Yeah. So
Some cases.
Somebody had to recognize them as interveners, making them parties, essentially.
Right. So, for example, in the case of Douglas versus Michelle, the 5th District in 1982 was presented with a question of whether there was public access to certain employee records of a hospital. The hospital employees were not in the case. They were allowed to intervene. And then the court went on to rule, but when you read the very opening of the case and you get that procedural background, there it is. They're in the case. In another case that's somewhat prominent called Hageman versus Andrews by the Supreme Court of Florida in 1970, it was a case involving something called the Governor's Club, and there was an effort to disclose who these people are and their personal information. The actual individuals were not in the case, but because what they called their associational privacy interests were at stake, they moved to intervene, and they were allowed to intervene. And then they presented all their evidence, and the court went on to rule On the merits, which is not the issue here today, the issue is the procedural due process. In one case, everybody seems to cite this case Shevin from the Supreme Court of Florida, where most of these cases cite back to it. It seems to be the sort of leading precedent here. That's a case from 1980.
You're coming up on 4 minutes, Vince.
Thank you, Your Honor. Let me just conclude with this then. In that case, there was a organization hired to conduct interviews to hire somebody for the state. And it kind of fits here because when they conducted their interviews, they took a lot of notes and they gave the interviewees assurances of confidentiality. They said, we promise this will never be revealed. And then, sure enough, later, somebody moved to have all this disclosed as a public record. And, of course, that was inconsistent with the assurance that had been given, just like in this case. But when you read the procedural beginnings of this case, what does it say? It says the district court became concerned that the persons interviewed, not then before the court, might have a constitutional right of privacy. The district court entered an order summarizing the contents of the papers and inviting the identifiable prospects to intervene under pseudonyms. The order appointed counsel to represent those interveners. Sua sponte, the trial judge in that case said, stop. The actual people most affected by this disclosure need to be before me because I suspect they have individual privacy concerns. And that's what happened. They were allowed to come into the case. The court went on to issue its rulings on the merits, but that's not where we even got to get to. These individual caretakers didn't get a single second in court. They didn't get any process of any kind to talk about their very, very important individual liberty interests and the very, very real threats to their personal safety. Thank you.
May it please the Court, my name is Pamela Jo Hatley and I represent Dr. Christine Storts. The interveners have stated that their issue on appeal is due process and whether the circuit court denied their due process when they moved to intervene. The standard of review when there's a motion to intervene was stated by the Florida Supreme Court in Union Central Life Insurance versus Carlisle. The court said this was a matter of the trial court's discretion. Appellate courts, therefore, will not disturb the trial court's decision absent a showing of abuse of discretion. Now, the caretakers have argued that in this particular case, because they say there was a denial of due process, that the standard of review should be de novo. And they cite GC and DC, parents versus Department of Children and Families, in support of that argument. But in that case, there were parents who faced a dilemma of their right to appear as witnesses in dependency proceedings, balanced again against their right to remain silent in criminal proceedings against them. They had asked the trial court, the parents had, to continue the dependency proceedings until after the criminal proceedings were over. Well, the trial court, in its discretion, denied their motion to delay the dependency proceedings, and they appealed. The Fifth District Court of Appeal held that this was a matter of discretion for the trial court, and the trial court had not abused its discretion. So GC and DC, the parents' case, is not applicable to the instant case to support a de novo standard of review. Whether to grant a motion to intervene is squarely within the trial court's discretion. Now, in this instant case...
Well, let's get to the heart. Is there something called private associational rights?
Well, Your Honor, are you referring to the members' association with this organization?
Yeah, I'm referring to Governor's Club, where the term private associational rights was used by the court.
In GC versus DC?
No, in the Governor's Club versus whoever it was. A case came out of Tallahassee a few years ago. I can't remember the site.
I'm sorry, Your Honor, I'm not familiar with that case.
Well, do you agree that is there something called private associational rights?
Well, in this particular case, Your Honor, this is a public agency. This was an agency that's acting on behalf of a government agency, and it falls within the public records.
Well, that's actually where I was leading. If you will agree that there's something called private associational rights, and I think there probably is. I mean, that's why you have the NAACP case. If there is such a thing, then how does that interface with the fact that this organization was the designated agency by Brevard County to handle the feral cat population, and that it took money?
Well, Your Honor, this case is distinguishable from the NAACP cases. In NAACP cases, there was not a public agency. In fact, the NAACP was being accused of subversion of the government, and Alabama, quite frankly, wanted them out. They wanted to get them out of town. So there was an accusation, and there was a request for the membership list, which was, frankly, to harass the members. And they were right. And it would have chilled, membership in the NAACP, most likely, because of everything that was going on during that time. However, in this case, the Space Coast Feline Network was admittedly an agency, and there was no argument from them below that they were not an agency. Clearly, they had entered the MOUs with as designated agency and accepted their responsibilities and accepted that designation. Also, they were receiving anywhere from $20,000 to $30,000 a year in taxpayer funding for traps to trap the cats, for a telephone line, and all this is in the record. They held the spay-neuter clinics at public facilities, Brevard County public facilities, so they were receiving funding. They didn't get a check payable to them directly, but they were receiving funding. So taxpayer money was going to support this program. So therefore, the taxpayers have a right to request public records to inquire into whether this program and this expenditure of public money is working.
But didn't the agreement state that that they would make public the locations of the places where cats were kept?
Your Honor, it did.
And did it say by district, or did it say by exact location?
It said by commission district.
Okay.
However, under the public records law, public records are defined to include, they're defined very broadly. It includes all documents, papers, letters, maps, books, tapes, so on and so on, that's received or made in connection with, or pursuant to law or ordinance, or in connection with the transaction of official business by any agency. So Space Coast Feline Network's records that fit that description are public records. Now, they may have had other records. They may have had records of volunteer members who did not register cat colonies. By the way, the ordinance required registration of cat colonies, and it required Space Coast Feline Network to train caretakers and to keep records on the caretakers. That was the ordinance. The MOUs required other things as well. But everything that Space Coast Feline Network did that was in connection to the feral cat program under the ordinance or under the MOUs, those were public records.
Was there anything requested by Dr. Stortz that was not included within either the ordinance or the memorandum of understanding?
Dr. Stortz sent an email to the director of Brevard Animal Services and Enforcement, and her email said, "Please accept this email as my formal public record request for the complete list of the registered feral cat colony locations as per the Animal Enforcement Ordinance, Brevard County Code 14, Section 4. And she went on to say, although BASE has designated this private entity as the agency for this information, these records are maintained on behalf of the county and are subject to the Public Records Act. Dr. Stortz did not request all the records. She did not request the membership list. She requested a complete list of registered feral cat colonies.
Is that what was turned over to her?
She got a list of street names, cities, and zip codes. No address, no names, no telephone numbers, which she didn't request.
Is she satisfied with that?
Well, no. And we brought that to the attention of the court, but that's not before the court today.
Well, can you have, I guess the problem that the appellant sees is is the turning over of street addresses and names, perhaps because they registered the cat colonies? Is that what, does that how the names and addresses get into the public record?
Well, apparently,
You didn't receive that.
Your Honor, we did not receive that. And, basically, the issue is moot at this point. She's received her list. Now, I believe the caretakers are concerned that other requests could be made, probably because the order out of the trial court was broad. It said records of Space Coast Feline Network and its predecessors. It had some predecessor organizations that, by the way, were on the MOUs as well. But it said records held by Space Coast Feline Network are public records. It did not say all records held by them are public records. It said records. Now, by definition, public records are what they are. They have to be made or received pursuant to, some governmental authority.
So would you concede that if a new request was made and they found out about it, that they could then intervene and make a showing that the disclosure of that information would directly impact them?
If there were a new case,
Yes.
Your Honor, certainly they could file a motion to intervene.
Would they have standing to intervene?
But, Your Honor, at this point, Space Coast Feline Network is no longer an agency. Now, it still has records, so far as I know, and so if there were a request for those records, and if they refused to give them, then if there was another case requiring their disclosure, certainly there could be another motion to intervene, which brings me to the point that they did not file their motion to intervene or to stay.
My question, though, assumes that they filed that motion to intervene prior to any disposition of the underlying lawsuit.
Well, again, are you asking about the...
I'm asking, it's a hypothetical, but I'm asking you to concede that they would have standing to intervene.
Well, as
long as they filed their motion prior to the disposition.
As a hypothetical, they could intervene, or they could request to intervene, and then that would be at the discretion of the trial court. Again, in Carlisle, there has to be an interest. There has to be interest in the matter that's in the pending litigation. The trial court has to determine that interest is appropriate to support intervention, and if it determines that, then it determines the parameter of the intervention. And as the Supreme Court of Florida said in Carlisle, there can't be any new issues brought in. There has to be sufficient interest there.
So at this point, Space Coast Feline Network is no longer a designated agency. You got the information that you want. And I guess I'm having a hard time figuring out why we're here.
I agree, Your Honor.
Okay, perhaps you can address that in your rebuttal. Is it possible to have a private interest in a public record? And should that be recognized?
I don't believe so.
Well, for example, my phone number and address are kept out of phone books and kept out of other public records because of the security reasons. If someone sought that information, which might very well be in a public record, would I have a private right to intervene to keep my address and phone number from being in the hands of other people?
Well, in the public records law, of course, there are specific exemptions, and that includes telephone address and so forth of judges, state and federal judges, and a whole host of other exemptions are in the public records law. But these caretakers do not fall within any exceptions. No, not as far as the facts of this case. But I would like to point out, because the court did question, the caretakers did not timely file their motion to stay or to intervene. The public records law at Chapter 119.11, Parent 2, requires that an agency disclose its public records within 48 hours whenever a court orders release of those records. It doesn't say 2 days or 2 business days. It says 48 hours. The court issued its order on May 19th. So 48 hours from May 19th. And by the way, Space Coast Feline Network was aware that order was coming down because it was given telephonically to their attorney and to me on the 16th.
Is that in the record?
Yes. Well, actually, it's in my record of my appeal of attorney's fees request. And as far as telephonically, you mean, Your Honor? As far as when the information was given to us?
No, I'm talking about anything in the record on appeal that would verify what you just said, other than your own statement to that effect.
Well, this instant appeal, and I apologize if it isn't, because there's been some going back and forth in this case. We had an attorney's fees hearing, and then we had an appeal of that.
You're aware, though, counsel, that we can't consider anything that's not in the record.
Of course I am, Your Honor. So let me back up and just simply say the order was issued on the 19th of May. And then 48 hours from that date, of course, would have put it on about the 21st of May. They requested their stay. I believe it was filed on the 25th of May. So that was 6 days after the order was issued. Their motion to intervene, of course, was after the fact. And Florida courts have addressed that in Dickinson versus Siegel and in Wags Transport Systems versus Miami Beach. Now, Wags was a land use case. It involved zoning. And in that case, it's a Florida Supreme Court case. The court said the end of justice would require to allow the interveners to intervene after the final judgment because it involved their property, their home. And they had bought their home in reliance on the existing zoning and so forth. So there was a very narrow exception. Wags has not been extended beyond the facts of that case. Several court cases have refused to extend that exception beyond the Wags exception, the Wags facts. So it's a very narrow exception. So their motion to intervene was late. There was no longer pending litigation. But back to their liberty.
The effect of the order had not been completed yet, right? The records by the time they intervened had not been disclosed. They intervened before they were disclosed. Is that correct? That's the impression I got from Mr. Thompson.
Well, I can tell you from my recollection that Mr. Torpy, and again, you know, we may be getting out of the record here.
Well, no, what I want to know is this. Would it make any difference in terms of your position regarding their ability to intervene if the order had been complied with or not complied with?
Not under the public records. Well, the public records law has to do with the stay, but quite frankly, the final judgment was up, so the cases that, you know, that come in under that, and of course the Florida Rule of Civil Procedure, which requires it to be a pending litigation, you know, it wouldn't make a difference. But as far as the specifics, you know, as
you're reading the pending litigation as the fact that an order had been issued.
The order had been issued.
Okay.
And the 48 hours were up.
Even though they're still within the time for motions for rehearing?
The records actually, yeah, I guess I would like to answer that question, but I don't know that it's in the record for this particular appeal.
Okay. All right, go ahead, Ann.
So, as far as their liberty interests, they have stated in their reply brief, the appellant stated that their sole liberty interest was their liberty to freely associate. But this case is about public records. And this is a public entity, or it was a public entity, a private entity working on behalf of a public entity, so therefore an agency as defined in the public records. Two cases in Florida, Mitchell versus Douglas and Forsberg versus Housing Authority of Miami Beach. In those cases, there were records that were very personal. In Mitchell versus Douglas, you had a tax-supported hospital where there were personnel records, and those records were deemed public records. In Forsberg versus Housing Authority of Miami Beach, the Florida Supreme Court held that information provided by public housing tenants that included their personal and confidential information on their family status, their income, their assets, and their medical history, that those were public records. So in the case at bar, you have an agency with records that were made or obtained in its agency responsibilities, in its registering of the feral cat colonies, in its training of new caretakers. And those records are public records. If there's no liberty interest in a person's personal family status and income and assets and medical history, certainly there's not in where they keep their cats, their cat colonies. Even if the cat colony happens to be at their address is not hidden. When you drive by the street, you see it. It's on their mailbox. You know, you can look it up in the property appraiser's website. It's not a secret. So it isn't confidential information. And where the cats are held, by, quite frankly, is a matter of public concern, because cats can present health issues, public health issues. They can spread disease and so forth. They also impact endangered species, listed species in the state of Florida. The taxpayers would like to know if this program is working. Is it being effective to reduce the population of cats? And are cats being kept in places where the public goes, or where the public's natural resources thrive, habitat that supports endangered species? So quite frankly, there's no liberty interest of the caretakers that was implicated in the proceedings below. And if there's no liberty interest, no constitutional issues, then there's no due process issues. So we respectfully request the court to affirm the trial court's denial of the motion to intervene and the motion to stay, which is quite moved.
Thank you, counsel.
Thank you.
Thank you, Your Honors. I'll try to make my points quickly. Number one, they did intervene before the records were disclosed. They attempted to intervene, that is, which was denied. In the one case that was cited...
You would agree, though, counsel, that your argument would be a lot stronger if they had moved to intervene before the judge ruled on it, wouldn't you?
Well, I'm not sure it would have been, the outcome would have been different. The judge denied their motion to intervene. They never had the chance to say one word about their First Amendment liberty interest or the threats to their personal safety. Procedurally, that would have been maybe a better fact pattern, but the minute almost immediately after the order came out and before the records were disclosed, they filed their motion, and that's when the trial judge should have stopped and heard from them. I want to clarify an important thing. They did not take any public money, the individual caretakers, and the network did not take any public money. The state did pay for the veterinarian fees that actually administered the neutering of the cats. But once they were released back to their locations, the individuals paid out of their own pockets and continue to do so for all the feeding and everything. They never received a single penny from the state.
The individuals did not.
The individuals did not.
Yeah,
My knowledge, nor did the network. The money was paid to the third-party veterinarians that actually administered the veterinarian care to the cats.
Now, Ms. Harvey has indicated that the Space Coast Feline Network is no longer a designated agency, and that the information that they were seeking has already been disclosed. So I guess I need you to address the mootness question.
Sure. They are no longer an agency. They seem to be satisfied with the information that's disclosed, at least right now. But the order itself is very sweeping and very broad. It says all records that are maintained by the network are public records, period, dating back to predecessor organizations long before the Memorandum of Understanding. So it's technically, after we conclude today, they could send a letter saying, open up all your files to us, and they would say, we have an order. That absolutely needs to be remedied. And I want to answer the most important question you asked, which is why are we here? We're here because there are critical First Amendment liberty interests at stake. We talked about, well, are there any statutory exemptions? We think there are, but we, the individual caretakers, we never got a chance to come in and present our evidence. And today we're talking about this network. In days past, we've talked about the NAACP, the NRA, organizations of all political persuasions. Tomorrow it could be disclosure of personal information about judges. It could be information about a faith-based network that enters into some kind of association with the state. They want records of where all these people worship, where they worship, et cetera. we have to get the process right. These principles are extremely important, and they're of critical importance to these individual caretakers. Right now, they've got a lot to say about statutory exemptions, about the evidence, and they want to put that evidence in the record because they think that when it's all heard, it will cause the judge to take a very different approach to the balancing of these two important public
Thank you, counsel.
interests.
Time's expired.
Thank you.
There's